I'll hear from counsel.
Thank you, Your Honor.
And everyone will have plenty of time to place anything you wish to place on the record, so rebuttal will be permitted from both sides. I want to hear everything you want to say.
May it please the court?
Yes.
Counsel?
Yes, sir.
Your Honor, this court has listened carefully and attentively to the last 2 days, and throughout these proceedings, the court has heard some truly unbelievable testimony. The concept of imposing or crafting any sanction on a case like this is a daunting task. But the defense hopes that this argument will help Her Honor in achieving that and in crafting the best possible sentence. Obviously, this is a case where emotions run high. The court has heard not only about the pain and the anguish from the Aiken and Mobley families, but the court has also heard about the absolutely wonderful and amazing woman so many people know Gloria Williams to be. And perhaps most importantly, the court has heard about the amazing and wonderful woman that young Kamiya Mobley has become. That said, Your Honor, it's the defense's perspective, and we would posit that in this case, after looking at the totality of the circumstances, after weighing all of the mitigators and all of the aggravators, that those mitigators far outweigh the aggravators in this case. And as such, it's the defense's contention that a sentence well below the maximum and much closer to the guideline range would be very reasonable and appropriate in this case. So without wasting too much more of the court's time, I want to start addressing some of those factors that the defense believes to be so mitigating, beginning with the fact that the defense would posit that Ms. Williams has demonstrated to this court, not only through her own actions, but also the testimony and the evidence that's been presented, that she certainly can lead a crime-free and productive life. And we would start, Your Honor, by addressing the fact that at 52 years old, Ms. Williams has no prior criminal convictions. During the 475 days she's been in the custody of the Jacksonville Sheriff's Office, she has not received a single DR disciplinary report. Both of these are important facts that speak directly to the conclusion that Ms. Williams can indeed abide by the nature and letter of the law. Beyond that, while I anticipate the state will likely get up and say that this was an ongoing offense, that every day that Ms. Mobley was missing, that essentially this offense was ongoing. However, there was uncontroverted testimony that Ms. Williams was around countless children, countless kids. Nothing like this ever happened again or ever happened since. And so we would certainly argue that this is indeed an aberration. As such, Your Honor, in looking even beyond that, Ms. Williams took steps to ensure that she would be able to be a productive member of our society. She got an education, she obtained her GED, and she worked 2 jobs at times, 1 job at others. She was able to support herself, and not only herself, but the 3 kids she was raising, Andre, Antoine, and Kamiya. This is significant, Your Honor, because obviously any parent and anyone who's going to be productive needs to be able to not only support themselves, but those that they are entrusted to care for. And Ms. Williams' ability to do that prior to this case and prior to continuing her education is certainly significant. She has gone on and increased her ability to be gainfully employed with the addition of several degrees, including an associate's degree, a bachelor's degree, and she was obviously in the process of obtaining her master's degree at the time when she was ultimately arrested. The court heard that Ms. Williams does indeed intend to continue her education. It may shift in a different direction, but she understands exactly that education is the key to being able to provide. And her actions speak directly to the fact that she does not seek or plan to be a drain on society. She continues to be able to desire to be productive. And so we think all of those things and her ability to remain crime-free is something that the court can feel comfortable with and would argue is certainly mitigated. That said, Your Honor, the defense would humbly and would respectfully disagree with some of the assertions of opposing counsel, specifically that it's impossible for someone to be a good person if they've committed a single crime or a crime like this. I think the testimony that came forward, Your Honor, indicated that Ms. Williams has helped countless people in a number of different ways, and her impact on the community in Ruffin, South Carolina is a significantly mitigating factor in this case. Well, it doesn't necessarily have anything to do with whether or not Ms. Williams committed some offense. That is not in contention or not in question. But the actions that Ms. Williams took through each and every stage of her life, and the actions she took volunteering, and we'll walk through each of these, are indeed mitigating, and they should be considered. We anticipate that as the court will ultimately consider all of the factors pursuant to the Banks case from the Florida Supreme Court, the court will look at the totality of the defendant, Ms. Williams' life, and the court will review all of the mitigating and aggravating factors.
Let me just ask you a quick question to both sides. I understand the Florida Supreme Court case of Banks versus State from 1999, but in this case, the sentencing range is time served up to 22 years. In other words, there would be no downward departure analysis for any
Correct.
sentence below the guidelines. I don't know what the sentence will be, but I just want that clear in the record.
Yes.
Downward or upward, there's no analysis.
Yes, and we would agree there's certainly no analysis, and we will obviously address the guidelines a little further on.
So you're arguing Banks by analogy in terms of the courts considering the totality of the circumstances and the aggravating and mitigating factors.
That is correct, Your Honor.
Okay.
And it's just ultimately something we anticipate the court will review, not because the court necessarily needs to in order to determine whether or not there's a need to deviate, but simply because it's part of just a solid analysis for how to consider what would be an appropriate sentence.
The thought process and the proper analysis to be conducted by the court under Florida law.
Certainly. And so for that reason, Your Honor, the defense does point that out. Specifically, the court heard that Ms. Williams is actively involved in her congregation, the Buckhead United Methodist congregation. Specifically, she's not only an avid attendee, but she's an active member. She is a member of the Parish Pastor Relations Committee, essentially one of the people who's in charge of ensuring that the congregation remains intact, ensuring that the pastor that they choose to essentially facilitate all of the people in the congregation is the person that they need and someone who can help maintain that congregation. It's an incredibly important role and was one that Ms. Williams took on a voluntary basis. Beyond that, the court also heard that Ms. Williams is a member of the United Methodist Women's Auxiliary, a group that provides volunteer and ministry work throughout Ruffin, South Carolina, which is incredibly significant. The court heard additionally Ms. Williams participated as a chair of the congregation's youth services, and in addition to doing that on a volunteer basis for 3 years, she also on 2 occasions attended a children's summit, the Harambe Summit, where essentially children were allowed to come to the church in sort of an idea where they could express themselves, engage with one another, and they kind of got the understanding that the church was in fact a safe place, a place for everybody. They sang, they danced, and it was an experience that the court heard from Pastor White that the kids really enjoyed having Ms. Williams there, and certainly asked her to come back again. Beyond that, Ms. Williams also assisted with youth services throughout the church congregation and was just active in every aspect of the congregation's life. The court heard that the congregation does certainly miss her, and we don't say that to say that the court can't impose a sentence because people will miss her, but simply to speak to the fact that Ms. Williams genuinely was an important part of the lives of the congregation, and her works were in fact good. And we think that's incredibly mitigating and should certainly be considered in this case. Beyond that, the court also heard that Ms. Williams' works were not dedicated solely to her church, but she was also involved in a number of other volunteer organizations, including the Tuskegee Airmen, which assisted not only with providing scholarship opportunities for high school students going on to college, but also the Order of the Eastern Stars. The court further heard that Ms. Williams was also active in the local PTA and PTO organizations dealing with parent-teacher relations, and again trying to ensure that not only her children and the children that she was raising, but other kids had, a good and safe environment to be educated in. And again, the defense would argue that this is incredibly important. In some of the letters that the court read, there were some comments that Ms. Williams never missed a parent-teacher or a parent-school function event. And again, the defense would argue that that's certainly significant. We would argue that it is mitigating. Again, a number of these factors don't necessarily undo or change the actions that Ms. Williams undertook, but they are still significant and should be considered. Now, just as important and just as significant as the impact that Ms. Williams had on others and others in the community, I think it's also important and significant to consider the impact and her achievements as a parent. And while opposing counsel posited that the most important role that a parent can give is to provide a moral soul, the defense would respectfully disagree. It would be the defense's contention that the most important job that any parent can give or has in raising their child is to teach them and provide them with the skills in order to be self-sufficient and in order to take care of themselves one day. It would be the defense's contention that while Ms. Williams may not have come into the possession of Kamiya Mobley through any lawful means or any, essentially acceptable means, that in that measure, not only towards Kamiya Mobley, but towards all of her children, Ms. Williams has succeeded. The court heard that at age 16, Kamiya was already looking for a job. That work ethic, that need to be able to get out into the world and actually achieve was something that she had instilled not only in Andre Bolden and Antoine Bolden, both of whom are gainfully employed today and are now caring and earning for their own children, but was also one that was instilled in Kamiya Mobley. And we believe that that's certainly a mitigating factor in this case. The defense would argue that the fact that Ms. Mobley was raised well, that she was raised in a loving environment, is certainly mitigating. It doesn't change the fact that, again, a kidnapping and interference with child custody occurred, but it is certainly vastly different from so many other kidnapping scenarios where children are taken into, whether it be sexual slavery, abuse, or anything of the sort. And so to say that this is the most heinous or horrendous is simply not true. Beyond that, Your Honor, there are a whole host of other aspects when it comes to parenting that Ms. Williams has done a phenomenal job with. Ms. Williams stressed to all of her children and all of the children she raised that education is incredibly important. As such, the court heard that at just 17 years of age, Kamiya graduated from high school. At no point was she ever not enrolled in school, and she continued on and graduated. And hopefully when everyone looks at that diploma, whether they be in the Mobley family, the Aiken family, or the Williams family or Bolden family, everybody feels pride for Kamiya, because they should. It's an incredible achievement, and it's important. Beyond that, the court heard that Kamiya does plan to attend college, and that's wonderful too. But instilling the importance of education, Ms. Williams did not only by words, but also by deeds. The court heard that Ms. Williams continued to go to school while she was raising these children. And her efforts and her striving to do that, again, led by example. Again, that's not to say that every parent is perfect, but it is important, and we believe it's significant. Beyond that, Your Honor, perhaps one of the other really great aspects of Ms. Williams as a parent was that she was able to make sure that all three of the children she raised felt truly loved. And that's not to say that they just felt good or that they're here because they have some sort of emotional attachment. But candidly, Your Honor, I think the court could hear it when the court heard the testimony of Andre and Antoine Bolden, how strongly they care about their mom, how much she played a role in their lives. Additionally, the court also saw it in some of those letters and those interviews that Kamiya gave, where she talked about how she was so loved, how she had the best life. And we believe those things are incredibly significant. We believe they are mitigating. It doesn't undo what had happened, but it is certainly important to consider. So many people could have done or made other decisions, could have raised children that were not loved, were not cared for, were not showered with affection and adoration. But that wasn't what Miss Williams did in this case, and it's certainly something that should be recognized. Now, we've talked a little bit thus far about Miss Williams as a parent, and I do think, while opposing counsel may disagree, it is important to consider Kamiya's wishes. And the reason for that is twofold. One, specifically because, at least as to the kidnapping, which is the more significant of the offenses for which Miss Williams is charged, she is the named victim. And so we believe that certainly her wishes should be considered. But two, besides Miss Williams herself, the sentence that the court ultimately imposes is likely to have the biggest effect on Miss Mobley. And so for that reason, we do think it's important. We certainly understand the state's argument that to allow someone who is brainwashed to benefit from that could seem strange, but at the end of the day, as much as the sentence that's imposed on Miss Williams is important, it's just as important to consider how this may affect or will affect Kamiya Mobley, who, through no fault of her own, is in a very precarious position. In that, Your Honor, the court read a number of articles, and Miss Mobley did make a number of statements to the media speaking about her wishes. The court also read the PSI in which Miss Mobley indicated she certainly didn't want Miss Williams to get a lot of time. In some statements, Miss Mobley stated she wanted Miss Williams to receive less than 10 years or not a very long period of time. She wanted the court to be lenient. In another, she said, "Don't lock her up and throw away the key. She loved me for 18 years, cared about me for 18 years. She made one mistake, but I was loved." And beyond that, she stated that she was given the best life. And as recently as January of this year, 2018, Miss Mobley stated that she's certain she's going to get time, but I'm hoping not very, very long. I think they should be lenient, and she took care of me very well. And so the defense would certainly put those forward because we believe they do matter and should be considered by the court in crafting a reasonable sentence in this case. Now, beyond that, Your Honor, another concept that we anticipate the court is going to contemplate, candidly should contemplate, is whether or not Ms. Williams poses any danger to the community or any danger to the public. It is one of the concepts that the sentencing analysis would generally ask and require a court to consider. And it would be the defense's contention that, at least in this case, the court can rest easy and does not need to worry that Ms. Williams continues to pose a danger to the community. The defense believes this for a number of reasons, but one of the most significant is the fact that Ms. Williams is not the same woman who took Kamiya Mobley back in 1998. 20 years have passed since that time, and Ms. Williams has not only changed as a person, but her situation in life has changed. The court heard a great deal of testimony about just how tumultuous Ms. Williams' life was prior to the taking. That testimony is not meant as an excuse, and it certainly does not excuse her conduct. But it is important in providing it context and providing the fact of just how confused, how out of it Ms. Williams really was. At the time, she had been in an abusive relationship, one that she was having a very difficult time leaving. She had lost custody of her 2 sons, and she had lost a child. Abused, broken, battered. And in that state, Ms. Williams made a mistake. She hasn't stated that she did anything else, or she hasn't stated that she hasn't violated the law. She clearly did. She's not saying that this is a result of some sort of mental condition, but in that state of confusion, in that state of absolute chaos, she did this. And we believe that's important because it's a state that Ms. Williams no longer has or is in. Today, as things stand, Ms. Williams has a loving husband, and the court got to hear from Runowski Williams. The court got to hear about how now Ms. Williams' relationship with her parents is no longer strained. She's active in their lives and they're active in hers. The court has heard that she has phenomenal relationships not only with her two sons, but also with the community as a whole in Ruffin, South Carolina. All of those things speak to the fact that Ms. Williams now has an incredibly strong support system, and one that she simply did not have back when she made and when she committed this offense. And so, again, the defense believes that this speaks directly to the fact that she is not likely to ever repeat the conduct that occurred in this case. Beyond that, the defense would again harken back to an argument that was presented a little bit earlier, which is that quite simply, Ms. Williams has had every opportunity and has been around children through the various organizations she's in, through her volunteering. If Ms. Williams was ever going to, likely to, or inclined to repeat this behavior, over the last 20 years she would have had every opportunity to do so, and she hasn't. And the defense believes that speaks again to the fact that this was clearly an aberration. This was not necessarily who she was. It's simply something that spiraled, got out of control, got too big. And yes, candidly, would it have been better if she had returned Kamiya? Ms. Williams testified, yes, it would have. It would have been much better. She was incredibly honest and open. She had to admit things that were bad, that essentially this was a selfish act. She doesn't deny it. But it doesn't change the fact that she no longer poses that same danger that she did at the time of this taking. Further, Your Honor, Ms. Williams is 52 years old. She's not looking to raise additional kids. She's hoping in the time that she has left that she can help others. And the court heard about her plans to hopefully, once whatever sentence is imposed expires, have the ability to do that. But again, it would be the defense's contention that Ms. Williams does not pose a danger to the community, and it's not a reason the court would need to impose some sort of lengthy incarcerative sentence in Ms. Williams' case. Now, the court heard a little bit about the fact that Ms. Williams did accept responsibility, and it would be the defense's contention that Ms. Williams certainly has accepted responsibility in this case. She's certainly waived her constitutional rights to a trial, to have this contested. She's spared not only the Mobley and Aiken family, but also Kamiya Mobley, of any kind of lengthy and arduous trial. And the defense would argue that that is, again, significantly mitigating. Well, yes, it is true that the parties reached an agreement regarding what the agreed upon range would be. It doesn't take away from the fact that that's still a mitigating factor and something that the court can and should consider in crafting a sentence, because it's not a decision that Ms. Williams had to make, and obviously had she chosen to do otherwise, many of the parties that were involved or did speak would likely have been subjected to lengthy depositions that would have been invasive, and she certainly made choices to spare all of those people from having to go through that. Beyond that, Your Honor, Ms. Williams again took responsibility for her actions and made sure that she publicly stated that the Mobleys and Aikens had absolutely nothing to do with this offense. Having not made any statements prior to court, it would have been very easy for Ms. Williams to have concocted some sort of carefully laid out scenario or scheme saying or blaming someone. But Ms. Williams was open and honest, and she stated, and she wants to clear the Aikens and the Mobleys of any alleged taint or any allegation that they were in any way involved. The defense would also argue that this is significantly mitigating. Obviously, it can't undo the pain and the harassment they've undergone, but the fact that she took those steps is certainly significant and should not be overlooked. Beyond that, Your Honor, while the court did hear that until today, Ms. Williams did not apologize to the Aikens, to the Mobleys, if there was any animosity about that, the defense would humbly ask that that be laid at the feet of myself and my co-counsel. Obviously, prior to today, would not have been appropriate for any defendant to make such a statement. Now, a little bit earlier, the court heard the state talking about the guidelines and about making some arguments regarding analogies, had this been 16 different one-year kidnappings, and the defense would like to discuss guidelines with the court because, again, even though they are in no way binding in this case, we do feel that they are instructive as a guide to the court. And the defense would agree that the purpose of the sentencing code and the purpose of the sentencing code in place, even at the time when these guidelines were in effect, was still punishment. And it says so right there in the law, 921.0016. That said, Your Honor, the defense would take a very different tact, and we would argue that the drafters of those guidelines also understood that knowing punishment was the goal, crafted it so kidnapping and interference with child custody only scored out to a guideline sentence of 67.6 months. And under the guideline sentence at bar or in play in Ms. Williams' case, or that would have been, had they not been waived, that would have been the guideline score. As such, that guideline score is presumed to be the appropriate sentence for an offender under that guideline scheme. Having said that, the court would then be allowed to vary or offer a variance of up to or below 25% in either direction, which would have been 50.7 months up to the 84.5 months. Obviously, the court could have gone above or below that if the court found significant mitigating or aggravating factors, similar to a downward departure as exists now under the current CPC. The defense would point this out because we believe the fact that Ms. Williams only scores 67.6 months under the guidelines, even knowing that sentencing is or punishment is the primary goal of sentencing, is still significant because that same guideline system established the idea that that is the presumptively appropriate sentence. Obviously, this is a serious offense. Obviously, there was a great deal of time that went by before Ms. Mobley was ultimately found and located. But again, Ms. Mobley was found happy, healthy, educated. And that's incredibly significant in this case. Now, the court did hear from both the Mobley family and the Aiken family about the pain and the anguish that this has caused. And neither Ms. Williams nor defense counsel can go back in time, can make them feel better, can undo or take away any of that pain. We're certainly sympathetic to them. Having said that, Your Honor, the imposition of a sentence is not going to change that pain. It's not going to take it away. It's not going to change what ultimately happens. Everybody who's in this courtroom who's waiting on the court to ultimately impose a sentence, and we realize it won't be today, is going to have to move forward in their own way. But the defense would argue that the sentence that the court will impose shouldn't be based on feelings simply of anger, but should be more crafted based upon a consideration of all of the factors, all of the parties, and then should be one that is appropriate, not designed merely to send a message, and we know the court is not intending to do such, but one that is essentially crafted and specified specifically for Ms. Williams based on the offense at bar, the mitigation, and the aggravation. Now, in this case, the court has heard a few requests, none from Ms. Mobley, Kamiya Mobley, but one from Shannara, asking for no contact or no contact to be allowed. the defense would simply argue that obviously Kamiya Mobley is an adult. She's over 18 or 18. I don't think there's any need for the court to impose such a sanction, especially since it seems that Ms. Mobley would have the ability to decide who she wants to have contact with, who she doesn't. Beyond that, Your Honor, while the defense understands one of the arguments that opposing counsel made, that essentially this offense created a significant amount of panic or fear within the general community of Jacksonville, the defense would actually take that argument and would flip it on its head. While a great bit of suffering and pain may have come from this offense, the reality is there's also some good that came from it. And that is that maternity wards all over the country have taken a vastly different tack towards security. And as such, offenses like this are exceedingly rare. And that's not in any way to justify what's happened, but it is simply a statement of what has happened, and it's something where society as a whole has benefited. And it's certainly something that should be considered or at least contemplated. Now, we did talk to the court a little bit about the guidelines at play, and candidly, cases like this do not come along very often. As such, the defense does believe it may be also instructive for the court to consider one or two other cases that have some similar factual elements to them. The court heard a little bit earlier, obviously, this is a case where Ms. Mobley was taken at a young age and then raised for many years. There was a somewhat similar federal case, it would have been the United States versus Ann Pettaway. It was a federal case. In that case, Ms. Pettaway similarly removed a child from a hospital. The child was 19 days old and was actually receiving medical care at the time. And the child was not ultimately located until the child was 23. Ultimately, in that case, the state, or I keep saying the state because I'm used to the state, the federal government and the defense reached a sentencing range of 10 to 12 and a half years. And Ms. Pettaway was ultimately sentenced to 12 years by that court. Having said that, there were some stark and marked differences between Ms. Pettaway and Ms. Williams that the defense believes are noteworthy. Specifically, Your Honor, in Ms. Pettaway's case, she actually removed the child that she ultimately abducted from potentially life-saving support. She actually removed the child from an IV, which was certainly, we would argue, exacerbating and significantly different from Ms. Williams' actions in this case. Ms. Pettaway was an active recreational drug user during the time she was raising this child. And the child Ms. Pettaway ultimately abducted and raised was in her care and custody for 23 years before she was ultimately located. All of these factors are, at least from the defense's perspective, are significantly more aggravating than those for Ms. Williams. And as such, the ultimate sentence she received of 12 years, the defense would argue that a sentence below that and more similar to either something less than the ultimate guideline range of the 84.5 months would certainly be appropriate in this case. There is another case that we would also direct the court's attention to, and while it has some significant differences, we believe it is certainly important. And it's the case of, I believe it is Warren Watson.
Do you have cites on these out-of-state cases?
I can provide the court
That would be
that.
fine.
It'll take me a moment. The other case is actually, it's an in-state course, and it's actually one I think that came in this division. And I apologize, it was State of Florida versus William Watson. It was a case where an individual, Mr. Watson, was owed money. He was not paid, and so he actually abducted a child of the person who owed him money in the hopes of getting that money returned. When it wasn't returned, he ultimately left the 2-year-old child on the side of the road. Thankfully, the child was found, and obviously the child was missing for a far less amount of time than was the case of Kamiya Mobley. However, the defense would argue that it's significantly more exacerbating as the child in that case was put in significantly more danger and risk of harm than Kamiya Mobley ever was. In that case, it resolved for a negotiated disposition of 9 years in the Florida State Prison. The defense, again, cites to both these cases signifying and for the proposition that a sentence of 84.5 months would certainly, or less, would certainly be reasonable in this case, given the fact that Ms. Williams never took any action to in any way harm or endanger Kamiya Mobley, and we think that's certainly significant. Now, the state did make a few assertions that the defense does want to take a few moments to counter or at least address. One was the fact or statement that certainly actions speak louder than words, and obviously the defense would agree. And while some of the actions that Ms. Williams took may not be the actions that are recognized or acceptable under the law, a vast number of the actions that Ms. Williams did take and that other people testified that she took are significantly positive and should not be overlooked. And so while we would agree that obviously actions speak louder than words, it does depend upon what actions you look at, and that the vast majority of Ms. Williams' actions in her entire life are positive and certainly speak to the fact that she is of good character. Now, there was also some mention in cites about the fact that essentially this case cost the Jacksonville Sheriff's Office a significant amount of money. They invested significant resources in trying to locate Ms. Mobley, and we do not disagree with the fact that they obviously expended such efforts or incurred such expenses. Having said that, Your Honor, the defense would also argue that the decision to expend or put those resources towards that would have been a decision made by the Jacksonville Sheriff's Office, not necessarily one made by Ms. Williams. Additionally, the state in reaching this agreement only asked for $500. Obviously, had there been a need for additional funds, the state could have asked for that.
With respect to that $500, at the appropriate time for imposition of sentence, would the state be able to bring a order on that $500 cost of investigation just so it can be documented at that time?
And Your Honor, it is part of the plea agreement on the Blue One.
Yes, it is, and it was discussed on the record. Thank you.
Obviously, the court has heard a great deal of argument from both sides. It's the defense's contention that ultimately the totality of the circumstances, all of the actions in Ms. Williams' life, the positive aspects of it, the wishes not only of a number of her family members, but also of Ms. Williams herself, of Kamiya Mobley, that a mitigated sentence is certainly one that the court should strongly consider. We haven't addressed too much, but I think it is important before stepping down. There were a few statements that weren't brought out during the direct examination, but did come out through some of the articles, statements that were made by Mr. Aiken. Specifically, he made statements to the effect that he was more angry at the hospital than he was with Ms. Williams, because there was no way that somebody should have gotten in that position where this could have occurred. Additionally, he also made a statement essentially saying that he couldn't really judge anyone because of the wonderful way that Kamiya turned out. And I believe the exact statement was, "I'm proud of the way she turned out. She did that, and that's why I can't criticize anybody. She was given every chance to make it in life. And that's all I can hope for all my kids." Well, obviously, there's nothing normal or nothing average about this scenario. Ms. Williams has taken every action she can to mitigate and to try to make the best out of a situation that simply got away from her. And as such, the defense is humbly asking that the court impose a sentence of no more than the maximum of what the guidelines would have been, which would be the 84.5 months in the Florida State Prison or lower. That said, we'd like to thank the court for, obviously, its time. And obviously, the court is not bound by those guidelines, but we'd be asking for a sentence of no more than that.
I appreciate all of that information and all of the information provided by the state. I have some questions for both sides. Does either side have anything you want to place on the record regarding the recommendation made by the Florida Department of Corrections within the pre-sentence investigation report? I'm not asking you to say anything about it. I'm asking you if you want to say anything about it. Because it's certainly a different number than both sides have proposed.
Correct. I disagree with it. I think the 22 years is appropriate. That's all I have to say about it.
Your Honor, again, the defense would disagree with it. We would have some different reasons. Obviously, we think it's more time than is necessarily necessary. We would also argue that I don't believe in this case probation would be necessary. Obviously, Ms. Williams is looking to ultimately return to South Carolina. I don't think that there's necessarily a need for the state of Florida to expend additional resources to monitor Ms. Williams. Additionally, given the support system that exists and given the lack of any other criminality, without any kind of substance abuse history, any kind of significant mental health history, there's really no need for a period of probation to be imposed. That doesn't mean the court couldn't, but I don't think it would be necessary. I also believe, and I can double check this, but the ultimate period of probation and incarceration that was recommended exceeded the 22-year cap, so that's another issue and another point that I think both sides would take with the recommendation. So ultimately, I certainly understand the recommendation, but we would ask the court not to rely on it.
It's just information. I would not be
I agree
relying
with the
on it.
probation comment, Your Honor. I don't think that's necessary.
Very well. And we all know what the recommendation was. It hasn't been placed on the record, but it did involve a term of incarceration followed by a term of probation. Was the recommendation of the Florida Department of Corrections correct?
Yes.
Yes.
And the only other thing we would mention, Your Honor, obviously, we reserved comment for the probationary report, just in terms of a recommendation.
Absolutely.
And so that was another reason why we would ask the court to not necessarily rely on that recommendation.
Very well. Ms. Williams waived the pre-sentence investigation report, and then I decided I wanted it to be ordered, and I addressed it on the record, and then I ordered it. Okay, I have a question for you, Mr. Lufrano. The state has argued that this was a continuing crime, that it's not just the act of actually taking the baby, it's the ongoing period of time, year by year by year, of the family being deprived of the baby. What is your position about whether it was an ongoing
Your
crime?
Honor, I believe we actually have a differing opinion, both myself and the state. It would be the defense's position that kidnapping is not an ongoing offense. Interference with child custody, which is only a sentence for which the max is 5 years, would be an ongoing offense. And so while the kidnapping would not be, and I think that there's case law, and I know Mr. Mizrahi and Ms. Johnson and I disagree on this point, but I think kidnapping is a finite event. Interference with child custody would be an ongoing offense. And so
There has to be case law that would guide us on this issue in terms of kidnapping. Your position, sir, is that it's an ongoing offense.
Absolutely. In fact, the defense pled to information that placed the dates of the crime from July 1st of 2000, July 10th of 1998 until July 10th of 2016. So, I think that in terms of whether it is an ongoing or not an ongoing crime, Your Honor, is really not, does not have a legal basis here since the defendant pled and we've agreed upon the sentencing range. I do think it is ongoing because I think the confinement was ongoing and based on fraud, and so she was confining this child for this period of 18 years with the purpose of interfering with the parent's custody. So I believe it is ongoing.
For the record, I have in front of me the amended information, and it does show in count 1 that the dates are between July 10, 1998 and July 9, 2016.
We're not disagreeing with what the information would state, Your Honor.
Very well. I had a question for you, Mr. Mizrahi. This is not the only time I understand that where the state has a case where the victims do not necessarily agree on their recommendations in terms of sentence. And so my question to you is, in this case, as I understand it, the biological parents of Ms. Mobley are both requesting the maximum sentence of 22 years, but Ms. Kamiya Mobley is requesting something below that.
That's my understanding. Your Honor.
Okay. Is there anything else, Mr. Lafrano?
Nothing further at this time, Your Honor, and obviously if the court would like any specific case sites regarding the ongoing nature of kidnapping, we'd be happy to provide that to the court.
I think maybe a one-page memo with that. I don't need anything complex on that, but just something to pin that down. One or two sites, even if they're just emailed to me, would be enough.
Okay. Your Honor.
And it's really not an issue on count two. I think the disagreement is on the kidnapping, but I'm very aware of the dates as pled, which may be sufficient for the analysis. So I'm not going to request any case law on that issue. What I would say is if you want me to consider something, you're welcome to send it to me, copy to the other side, so it's your option. On that Petaway case, if and when you have the site, if you wouldn't mind sending it to me, copy to the state.
Certainly.
Does the recommendation of the pre-sentence investigation report need to be on the record?
No, Your Honor.
I'm sorry, Your Honor.
Does the pre-sentence investigation report's recommendation need to be on the record since it's been referred to today?
I think if the court wants to, the court can place it, but I don't think it's necessary. I don't think either side is requesting it.
Okay, I'm not requesting to place it on the record. I just wanted to make sure that we had addressed that.
Thank you, Your Honor.
Well, go ahead.
Well, I wanted to have a brief rebuttal as to the cases that are similar, Your Honor.
Sure.
First of all, I mean, I think obviously it's your decision. And Mr. Aiken said that he can't judge, but guess what, Your Honor, you can. And it is your job to judge this case. But yeah, I don't think the court should really consider other cases because every case is different. But I would point out that Judge Mahan here in Duval County Courthouse in 2010 did have a similar case, probably the most similar case that happened in this local jurisdiction, more similar than the 9-year case, is a woman, her name is Jasmine White. And there's not a case site just because it was never appealed or anything, but it's in the court record. You can search the media sites. And Jasmine White was she was young, she was 19 years old, and she pretended like she was a DCF worker and tricked a newborn mother. She actually followed him home from the hospital. Tricked a newborn mother into giving her child to a pretend DCF worker. She took off with the child. She left behind some paperwork at the mother's home, and a fingerprint led to her to her capture. She was caught 13 hours later. She was sentenced to 18 years in Florida State Prison, followed by probation. Obviously, she only was 13 hours with this child. The biggest difference in that case and this case is the Florida sentencing guidelines had already been changed. So there was no top of the guidelines. So, the court didn't have to worry about an 80-point whatever top of the guidelines, and the defendant pled guilty and Judge Mahan decided that the 18 years was appropriate. So I just wanted to put that on the record as another instructive case for Your Honor.
Thank you so much. If I may please speak with counsel at Sidebar regarding the upcoming schedule, and then we're about done for today. This is a very unusual case, and I'm going to take my time considering everything that has been presented to the court to make sure that I am as thorough as possible. So what I have done is I have ordered the transcripts from yesterday's proceedings and today's proceedings. Those take 10 regular business days. I don't want to spend taxpayer money on rushing it. I think that the 10-day normal delivery is very reasonable. So 10 business days from today would take us to Friday the 18th for me to receive those transcripts. Sometimes it takes a little bit more than 10 days, especially when you've been in court as many hours as we've been in court. And then I will be at the Advanced Judicial Studies class the end of May, which is basically continuing education for judges. So my plan is to work on a sentencing order and come back at a specific date for imposition of sentence, and I should have an order ready to go by then. I've just spoken with both sides, and I believe both sides are available on Friday, June 8th, which is just about a month away, and that's exactly what I had estimated on the record at a prior court date, that I thought it would be 3 to 4 weeks after the conclusion of the sentencing hearing. So we're right on the track that I had previously anticipated. So imposition of sentence will be scheduled for Friday, June 8th at 10:30 a.m., special set from 10:30 to 11 o'clock a.m. And counsel for both sides are available at that time?
Yes, Your Honor.
Two things to address with counsel. When I work on the sentencing order, I might choose to reference what the recommendation was of the Florida Department of Corrections in that order, and I might choose not to, and I just want to, I'll think about whether I want to do that, how it impacts my analysis. So it certainly is being considered, but I just wanted to establish on the record, does either side have any objection to that recommendation number being disclosed in the order, if I choose to do that?
No, Your Honor, I think the recommendation itself is part of the confidentiality of the pre-sentence investigation.
Do you have you believe the so your indication is you have, certainly the pre-sentence investigation report is confidential, but you don't have any objection, as I understand your position, in the court disclosing what that recommendation was, if it's something that I think needs to be considered. Well, it will be considered, whether or not I include it in the order, but you don't have any objection to it being included in the order?
The state
Same
has
for
no
the state.
objection, no.
Okay. Then the last thing is, on this legal issue of whether kidnapping is an ongoing crime or not, my understanding is that the defendant has pled in count 1 to kidnapping, with the dates being between July 10, 1998 and July 9, 2016. So the defendant has pled to that kidnapping count as charged with those dates between those years. So in any event, the defendant has pled guilty to that charge with those dates, and in any event, I believe both sides agree, the court may consider the resulting harm to the victims based upon that time frame having elapsed.
That's the state's position. I believe defense is in agreement.
To the victim, yes, ma'am, that's named in count 1. And when Mrs. Williams entered that plea, it was with a waiver of any Florida State court defenses.
Very well, and Ms. Kamiya Mobley is the only victim listed on the kidnapping count
Yes, sir.
in terms of the listed victim.
Yes, sir.
Very well. I appreciate so much all of the hard work of the attorneys, the professionalism you have all demonstrated today and throughout the pendency of this case. I appreciate all the hard work of everyone involved in the case, all of the time and attention that everyone has dedicated themselves to. And I know that it may seem like a while to wait for a month, but I really want to have those transcripts, and I want to make sure I can work on my orders so that I'm satisfied that I have been as thorough as possible. So at this time, I believe we're concluded for today. I'm actually not done with court for the day. We have a 4 o'clock hearing that'll be in 10 minutes, but we'll be in recess, although let's talk about the place for imposition of sentence. I haven't reserved this courtroom for that day, and so I think what I'll do for now is I'll pass it to the regular courtroom that I work in, which is 408. If anyone wants to bring a request to the court's attention to move it into here, then we'll need to address that at a later time, is what I would say. I haven't reserved this courtroom for that day, and so for now, we'll just be in here. If we need to move it, we can address that. Thank you. So this case is passed to Friday, June 8, 2018 at 10:30 a.m. It's a special set 30-minute hearing from 10:30 to 11 for imposition of sentence, and we'll be in recess until 4 o'clock when I have another matter.
Thank you, Your Honor.
Thank you.